Hi, everyone. Welcome. As we're waiting to get started, feel free to add your name to the chat and let us know where you're joining from today. We'll get started momentarily. And I'll give folks just one more minute to join before we get started. Feel free to introduce yourself. Let us know where you're joining from. All right, so for the sake of time, I'm going to get started. Welcome everyone to our second Legal Network for Gender Equity webinar of 2023. Abortion Rights and Legal Protections for Pregnant Workers in the Post-Dobbs Era. If we've not had a chance to meet, I'm Lizzie Vogel, Senior Counsel at the Times of Legal Defense Fund, Legal Network for Gender Equity at the National Women's Law Center. I'm so excited today to hear from our esteemed speakers, who I'm also fortunate to work alongside every day, and I'm going to introduce them momentarily. With all the recent changes to the law limiting abortion access, as well as the recent passage of the Pregnant Workers Fairness Act, I think the urgency of this webinar really speaks for itself. But I am particularly looking forward to hearing from our speakers as they're going to be discussing these developments within the context of the work you all do on behalf of workers. Before we dig in, I want to extend my sincere thanks to those of you who have made today possible. First, to our attorneys in the Legal Network for Gender Equity. Thanks for being here today and for all the work you do on behalf of survivors. Thank you to our fabulous presenters, Galen Burrows and Noel Leon. I'm still looking forward to learning from you today. And finally, my colleagues at the Law Center, specifically Danny Stewart, Jennifer Mondino, and Sky Seeley, whose work behind the scenes has been tremendously helpful in making today happen. So now to introduce our speakers. I'll keep this brief so we can maximize the amount of time we have to hear from them. And a longer bio for each speaker is going to appear briefly on the screen. You can also access that once we post the slides on our websites. And I'm going to introduce them in the order that you'll hear from them today. So first we have Noel Leon. Noel is the director of the Abortion Access Legal Defense Fund at the National Women's Law Center, which will officially launch in July 2023. Noel recently rejoined the Law Center and brings extensive experience in the reproductive justice space, having previously done related work as a civil rights litigator and also in a previous stint at the Law Center and as a case manager for the DC Abortion Fund. Next, we'll hear from Galen Burrows. Galen is stepping in for Laura Narefsky, who unfortunately couldn't be here because of an unexpected conflict, but we are really grateful that Galen could step in. She's the Director of Workplace Equality and Senior Counsel here at the National Women's Law Center. She too brings extensive experience in the field of workplace equity. Before joining the Law Center, she previously worked at the Leadership Conference on Civil and Human Rights, Feminist Majority, and the Bronx Defenders. So for the format today, we're going to have individual presentations by Noel and then Galen. Noel's going to start by anchoring this presentation with some background on abortion terminology and relevant law. Galen's going to then discuss protections for workers under the Pregnancy Discrimination Act and Pregnant Workers Fairness Act. Then Noel will briefly share some resources at the Law Center and other organizations that we work in coalition with that can assist with the issues that we'll be discussing today. And then we will have ample time for questions from all of you. And I just want to note that some of you did send in questions through the poll that we sent out in advance. Thank you so much to those of you who did. Those questions have been shared with Noelle and Galen, and they will try their best to address them in the presentations today. But if you have any follow-up based on what you hear today, of course, feel free to build on those questions. In the end, we're going to, like I said, we're going to invite you all to submit questions. Feel free to do so through the Q&A function in the webinar. And we will read those questions after the substantive presentations and try our best to get to everyone's questions. But if you don't have your question addressed today, Noel and Galen will also provide their contact information at the end so you can follow up. A few housekeeping notes. So the webinar is being recorded. As always, we will share the recording on our website within the next few weeks, as well as a copy of the slides that you see today. If you have any questions about logistics or technical issues, please send them to me or Danny Stewart through the chat function on the screen. And I'm going to now turn it over to you, Noelle.
Thank you so much, Lizzie, and hello, everyone. It's nice to meet you all virtually through this webinar, and thank you for the work that you do for the Legal Network and all of your clients. As Lizzie said, I'm going to start out by doing a kind of basic abortion care 101, and then we'll do a bit of the kind of very core what's going on, what is the state of the law such as it is around abortion right now. We know that abortion is one of the most regulated, restricted medical procedures of all time. And for that reason, we think it's important that lawyers understand some of the terminology and some of the medicine around abortion. So you can go ahead and go to the first slide. So yeah, first of all, just to define abortion, what we're talking about today, for our purposes, the way we understand abortion, it's the use of any means to intentionally terminate an individual's pregnancy, excluding labor and delivery. Now, some states actually define abortion differently in ways that can then enable perhaps an overzealous prosecutor to use them to target situations that may not be termed an abortion through normal medical practice. But for our purposes today, this is how we're defining abortion. Next slide. So abortion is incredibly safe. It is more than about 14 times safer than carrying a pregnancy to term. As gestational age increases, the complication rates do increase somewhat, but it is very safe through all stages of pregnancy. And when you see claims by anti-abortion legislators or activists that there are concerns about safety, those claims are by and large roundly rejected by trusted medical authorities, even when they do end up in law. So on to the next slide. I'm going to talk a little bit about gestational age and measuring pregnancy. So in the medical field in obstetrics and gynecology, pregnancy is typically measured by LMP, meaning last menstrual period. And so when you hear someone say that they're 15 weeks along, that generally means it's been 15 weeks since their last menstrual period. However, of course, conception actually happens approximately 2 weeks later generally. And so in laws, sometimes they are referring to a moment of conception as the way that a particular gestational ban is defined. And sometimes they are not referring to conception. So if you see a law that says that abortion is banned at 12 weeks, that means 12 weeks LMP. But if you see that there is a ban at 12 weeks past conception, that's actually operationally a 14-week ban because it's an additional 2 weeks since the last LMP. Conception, of course, being the moment of fertilization. A quick comment about trimesters and viability. So trimesters are a kind of loose framework in the medical field to understand different portions of pregnancy. They do not start and end at fixed dates during pregnancy. They are approximately between, for the first 14 weeks of pregnancy, approximately between 15 and 28 and approximately 29 to 40. and viability, even more so than trimesters, is really not a meaningful medical term beyond an individual pregnancy. Viability in the medical field is referring to the ability of an individual pregnancy, a child born of an individual pregnancy, to survive outside of the womb, and that relies on a range of factors, gestational age being only one of them. And a huge factor in whether or not a pregnancy is supposedly viable is what kind of access to medical care the person has, and many other circumstances that is impossible to predict until the time that perhaps the labor and delivery is happening. So the way that it is used in legislatures is largely political, and latching onto an idea that viability connects to a specific gestational age that applies across pregnancy. That is not a medical concept at all. Additionally, that's all right, but I will just a quick note on the heartbeat ban versus 6 weeks. A heartbeat is, again, not a very medical term. At approximately 6 weeks, there's electrical activity that happens within a pregnancy that is sometimes called a heartbeat. It's not truly a heartbeat. It's a sound that there's a sound produced by the machine based on electrical activity. On to when they're referring to heartbeat bans. Additionally, the 6 week cutoff for those estimate for those bans is an estimate only, and any individual case requires actual ultrasound for confirmation of whether or not there is a quote unquote heartbeat present. Okay, you can move to the next slide. So there are a couple of main categories of abortion. The first category is procedural abortion, or the intentional termination of a pregnancy using instruments. You may have heard of this erroneously being called surgical abortion. It's not actually a surgery because there's no incision, and their surgical environment is not required, therefore, for a procedural abortion to take place. So there are a couple of the main procedural abortions are mechanical or manual vacuum aspiration, which can occur up through about 15 or 16 weeks. And it's a very quick procedure that is easy within one visit often. Another type of procedural abortion is a D&E, or a dilation and evacuation, that starts around 15 weeks LMP. It's a slightly longer procedure, but often requires 2 to 3 or 1 to 2 or 3 sometimes days of cervical prep before the procedure, which is why for those procedures a little later in pregnancy, it can take a few days of a patient having to come back to the office in order to complete the procedure because of that cervical prep that's required. So we can move to the next one. The next category of abortion, which may be on everyone's minds right now, given what's going on in the courts, and we'll talk about that, is medication abortion, or the intentional termination of pregnancy using one or more medications. This is now, medication abortion is the most common form of abortion in the US. More than half of US abortions are medication abortion. And the most common protocol is a 2-medication protocol of mifepristone and misoprostol, or Miffy and Miso, or Miffy and Miso. Mifepristone works by starting the abortion by first blocking progesterone to stop the pregnancy from continuing. And then some number of hours later, misoprostol is taken in order to cause the uterus to contract and empty. Mifepristone is highly regulated by the FDA and is approved up to 70 days LMP, although this is on hold right now, which I'll come back to in a minute. It is FDA approved up to 70 days or 10 weeks LMP, taken along with the Miso in the Miso protocol, Miffy-Miso protocol. It is extremely safe and effective. We have decades of evidence now, and it's over 99% effective, and as you can see, less than a 0.4% risk of major complications. It's extremely safe and effective. There's also another regimen that's a misoprostol alone regimen that's extremely common around the world. It's also very safe and effective, and is sometimes used in the US too. although the MIFI-MESO protocol is the most common protocol. You can go to the next slide. So mifepristone, this is the medication that you are probably hearing about in the news, because there are two cases, one in Texas and one in Washington, both suing the FDA, asking courts to require the FDA to do opposite things with respect to mifepristone. Already, I created these slides and finalized them on Tuesday, and already this slide is out of date. But so I will speak over it, but please know it is slightly out of date. So the FDA approved mifepristone in the year 2000 through a special process that ultimately resulted in imposing a REMS, which is just a tightly controlled distribution mechanism. It imposed a number of rules under the REMS, including a requirement that only physicians prescribe mifepristone, that they become certified with the manufacturer of mifepristone, that they require the patient to sign an agreement, and that it only be approved up to 7 weeks gestation. So on some of the most significant restrictions have been lifted in the last several years. In 2016, several of them were lifted, including allowing other providers to prescribe, other than physicians, other prescribers can now prescribe mifepristone, such as nurse practitioners or other advanced practice clinicians. And in 2021, during the pandemic, the FDA also lifted its requirement that it be dispensed in person, which was a really major advancement, allowing for telehealth and provision of mifepristone through the mail. Now, and we can come back to this in a little bit, but now the Fifth Circuit just today has rolled the FDA, the current status of mifepristone, back to prior to its 2016 changes. So we are now operating, as of tomorrow evening, we are operating under the FDA's 2000 imposed restrictions on mifepristone. Only up to 7 weeks, must be prescribed by a physician, and requiring that in-person accessing of the medication. You can move to the next slide. Oh, great. Yes. So now we're going to kind of step out of the medicine. We've already started doing that into the law, and to go back a little bit before Dobbs, so that we set the stage for where we are now. In 1973, as you know, Roe v. Wade recognized the fundamental right to an abortion as part of an individual's right to privacy, grounded in the Due Process Clause of the 14th Amendment. And under that decision, the court did it, had reasoning of finding, tradition and history of privacy that laid the groundwork for the right to abortion. Additionally, it talked about a sort of trimester framework through which states do have an interest in so-called potential life, but that interest increased over the course of the pregnancy. So during the first trimester, it didn't have very much interest in, and a woman's fundamental right to have an abortion was, predominant in the first trimester. And then throughout the pregnancy, they kind of came together. In the kind of key takeaway from that case is that states could not ban abortion before quote unquote viability. And this was in 1973. So the next big case to come around was Planned Parenthood v. Casey, to come up to the Supreme Court to reassess the core holding of Roe was Planned Parenthood v. Casey in 1992. And at that time, advocates were extremely concerned already that Roe was going to be overturned. Instead, a plurality of the court affirmed the core holding of Roe and held that states cannot ban abortion before viability. However, states can regulate abortion before viability so long as that regulation does not pose an undue burden to the individual seeking an abortion. This undue burden standard was new. It sort of replaced Roe's trimester framework. Under the undue burden standard, states could not pass restrictions on abortion if they had the purpose or effect of imposing a substantial obstacle in the path of a person seeking to terminate a pregnancy. So at that point, the two big rules around abortion were states could not ban abortion before viability, and states can only regulate abortion as long as it doesn't pose an undue burden. Now, already with Casey, the Supreme Court, Casey itself involved a challenge to a Pennsylvania law that included a number of restrictions, and the court actually upheld all but one of those restrictions. The only restriction that it held was an undue burden was the spousal notification provision that required someone seeking an abortion to notify their spouse that they were getting an abortion. Over the next 30 years, litigation progressed. You can go ahead to the next slide. So litigation progressed, legislation abounded, anti-abortion activists mobilized and really were effective at getting laws introduced in the states that would really test the undue burden standard and chip away at individuals' access to abortion, even under this standard. Over that time, the vast majority of restrictions that were passed into law, when they reached the courts under this undue burden standard, were upheld as not being an undue burden. So throughout this time, abortion was pushed out of mainstream medicine. It ended up in clinics that were sort of separated from other medical practice, and that made it easier for anti-abortion activists as well as legislators and prosecutors and agencies to target abortion providers, patients, and advocates. So, however, throughout all this time, the core holding of Roe that states cannot ban abortion before viability did hold, and so courts would strike down when any laws that states actually passed that were pre-viability bans. Now, during the last about 10 or 15 years, legislatures really got bold and decided that they were going to start trying to pass these bans anyway. So they started passing 20-week bans and 15-week bans and 12-week bans and 6-week bans. And even though they were getting shot down, they continued to pass those laws. This, of course, accelerated after the election of Trump and, of course, the installing of new justices on the Supreme Court. So this brings us to Dobbs. You can move to the next slide. So Dobbs involved the very last abortion clinic in Mississippi, challenging Mississippi's 15-week ban. Now, 15 weeks is well before viability by any medical argument. There have been some arguments about whether 20-week, 22-week, 24-week might qualify as viability or not, but a 15-week ban is pretty clearly pre-viability. So the only way for the courts to address this was to address Roe's core holding of whether states can ban abortion prior to viability. And the Supreme Court held last summer that, you can move to the next slide, that Roe and Casey, the core holdings, were explicitly overruled and that there is no right to abortion under the US Constitution. The opinion purports to return the issue of abortion to the states and to the state legislatures. It sets up a supposed standard for reviewing abortion laws that essentially defers entirely to anti-abortion legislatures and enables them to do exactly what the court did here, which was to rubber stamp Mississippi's 15-week abortion ban based on Mississippi's representation that it was doing this because it has an interest in this unborn life. So in the language of the opinion, it grants a strong presumption of validity to laws that regulate abortion because of states' legitimate interest in respect for and preservation of prenatal life at all stages. So since Dobbs, you can move to the next stage. There has been an absolute chaos in the legal landscape around abortion. There are now 19 states in which abortion has been banned or made inaccessible post-Dobbs. And those bans include bans that are trigger bans that legislatures had passed years ago with the hope and anticipation that Roe would be overturned. They also include pre-Roe bans. They also include very, very early bans, such as 6-week bans, which effectively make abortion inaccessible in that state. There are also complex criminal codes that now anti-abortion prosecutors and zealots can and have, in some cases, used to target patients, providers, and supporters of abortion, and leaving all of those individuals really fearful about their legal liability. Additionally, anti-abortion activists are increasingly emboldened to take action against abortion patients, providers, and those who support abortion. In Texas, you may have heard there is a man who has sued 3 friends of his ex-wife for wrongful death because they allegedly helped his ex-wife obtain abortion pills. This is the kind of action that we're seeing begin in the states that is leaving people so terrified about what their rights and liabilities are. And right now we are actually in the first state session post-Dobbs, and anti-abortion lawmakers are at lightning speed introducing new legislation that target abortion providers and helpers, and the impact of those laws, any laws that ultimately go into effect, is going to be very challenging to work out and leaves a lot of people confused and afraid. You can move to the next slide. Then finally, we have the current mifepristone litigation I was referring to earlier. In the Texas case, Alliance for Hippocratic Medicine versus the FDA, an organization, well, no, there are a number of plaintiff organizations, but there's an organization that incorporated in Amarillo, Texas, with the explicit purpose of getting this case before Matthew Kaczmarek, who is an extremist judge with a history of anti-abortion ideology. And they brought this case asking the court to stay or block the FDA's year 2000 approval of mifepristone. On just last Friday, and as you can see, the slide is only current as of 2 days ago, but just last Friday, Judge Kaczmarek issued a nationwide injunction to quote unquote stay the FDA's 2000 approval. On the same day, about half an hour later after the Texas decision came out, a preliminary injunction also issued in the state of Washington in a case where 17 attorneys general in 17 states and the District of Columbia sued the FDA, asking the FDA to remove the remaining restrictions that are on mifepristone because it has such a stellar record of safety. The judge in Washington preliminarily enjoined the FDA from altering the status quo and rights as it relates to the availability of mifepristone under the current operative January 2023 REMS in the 18 plaintiff states. Of course, these two opinions are in direct conflict with each other seemingly, and leaves the FDA in an untenable position. Already, the DOJ has moved to stay. Well, the Texas case, Judge Kaczmarek stated that it would not go into effect for 7 days. And so it is currently not in effect until tomorrow evening. And the DOJ has already gone to the Fifth Circuit and asked them to extend the stay. The Fifth Circuit just today responded stating that it was that the decision was stayed only with respect to the 2000 approval, but that the FDA's 2016 and 2021 relaxation of restrictions on mifepristone could not remain. And so the Fifth Circuit has rolled us back using much of the same extreme anti-abortion language that's in Judge Kaczmarek's ruling, and utterly faulty and lawless reasoning has rolled us back to the extremely restricted state of affairs under the FDA's 2000 mifepristone restrictions. So that's what's currently going on. And as you can tell, the entire landscape of abortion care, abortion access is incredibly confusing, is constantly shifting day to day, and aside from leaving people very unsure about their liability, and indeed maybe in some cases truly exposed legally, it has an enormous chilling effect on individuals who might seek to provide abortion, seek to help other people obtain abortion. And this is all part of the anti-abortion movement's strategy to confuse and complicate the legal landscape in order to make abortion disappear, even without having to get all the way to making it utterly nationally illegal, which would be the ultimate goal of these groups. I think that's all my slides, and I am happy now to turn it over to Galen before we talk a little bit about resources.
Thank you. That was incredibly sobering. But thank you so much for the presentation, Noelle. And good afternoon, everyone. My name is Galen Burrows, and I'm the Director of Workplace Equality and Senior Counsel at the National Women's Law Center. I'm happy to be here with you all, and I am subbing in for my colleague, Laura Narevsky, who, as Lizzie said, was unable to make it. Laura works on our pregnancy and caregiver discrimination portfolio, and we worked closely together to advocate for passage of the Pregnant Workers Fairness Act. And I have to thank her for the preparation for this webinar. So switching gears slightly, I want to talk briefly about the protections for pregnant workers in two federal laws, the Pregnancy Discrimination Act and the recently enacted Pregnant Workers Fairness Act. Given our time today, this discussion will of course not be comprehensive, but I'm going to try to give a quick overview and then focus primarily on the aspects of these laws that might be used to protect workers seeking abortions. Next slide, please. So I'll start with some background on the Pregnancy Discrimination Act, or the PDA, which most of you are likely already familiar with. Put simply, the PDA prohibits workplace discrimination on the basis of pregnancy, childbirth, or related medical conditions, including abortion, and requires that workers affected by pregnancy, childbirth, or related medical conditions are treated the same as other employees who are not so affected, but are similar in their ability or inability to work. So pregnancy discrimination includes treating an employee or job applicant unfavorably with regards to hiring, firing, pay, job assignments, promotions, layoffs, training, fringe benefits, or any other term or condition of employment. But to be clear, it also includes discriminating against someone for having an abortion or contemplating an abortion. And we'll talk a little bit more about that later. So before Congress passed the PDA in 1978, it was common for employers to categorically exclude pregnant workers from the workplace. The PDA provided a vital source of protection for pregnant workers against discrimination. So you can't be treated negatively because you are pregnant or because of something related to childbirth or abortion. But the PDA has fallen short of providing robust protections for pregnant workers who need affirmative on-the-job accommodations to allow them to continue working. In 2015, the Supreme Court ruled in Young v. UPS that when an employer accommodates workers who are similar to pregnant workers in their ability to work, the employer cannot refuse to accommodate pregnant workers who need it simply because the accommodation is more expensive or less convenient. The court also held that an employer that fails to accommodate pregnant workers violates the PDA when its accommodation policies impose a significant burden on pregnant workers that outweighs any justification the employer offers for those policies. So the Young decision was an important victory for pregnant workers, but the multi-step balancing test it set out still left many important questions unanswered and created uncertainty about when exactly the PDA required pregnancy accommodations. Courts have also narrowly interpreted the requirement for pregnant workers to find a similarly situated comparator, which often created an insurmountable burden for workers to prove their cases. So put a different way, even after the Supreme Court affirmed that a refusal to accommodate pregnancy could run afoul of the PDA, workers denied accommodations continue to have their cases thrown out of court. Research done by A Better Balance, one of the lead groups that advocated for changes in the law, found that in 2/3 of cases decided since Young, employers were permitted to deny pregnant workers accommodations under the PDA. Next slide. Thanks, Danny. So to address this gap in federal protections for pregnancy accommodations, last year, Congress passed the Pregnant Workers Fairness Act, the PWFA, which requires covered employers to make reasonable accommodations to the known limitations related to pregnancy, childbirth, or related medical conditions of a qualified employee, unless the employer can demonstrate that the accommodation would impose an undue hardship. The PWFA, like the PDA, applies to employers with 15 or more employees, as well as to federal, state, and local government employers. It requires those employers to make reasonable accommodations when an employee has a known limitation. A known limitation is a physical or mental condition that is related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions that the employee has communicated to the employer. Give me 1 second. Sorry, my computer just, give me 1 second. My computer just went nuts. Can you guys still see me?
We can see you and hear you.
Okay. All right, I'm going to come back. Apologies. Okay, so I was talking about a known limitation. Okay, so a known limitation is a physical or mental condition that is related to, affected by, or arising out of a pregnancy, childbirth, or a related medical condition that the employee has communicated to the employer. And this is really important. There are some known limitations that may be obvious to an employer. So maybe needing a chair or stool, or needing to use the bathroom more frequently. But there are others that won't be obvious. The law doesn't say how an employee must communicate a need for an accommodation. So for example, the law doesn't require someone to use any magic words to invoke their rights. There's no explicit requirement for a doctor's note, nor is there anything in the text about how much information an employee must provide. All of that is still yet to be worked out. The PWFA also relies on the same interactive process for accommodations set out by the Americans with Disabilities Act, meaning that an employer should engage in an interactive discussion with the pregnant worker to find a reasonable accommodation that will allow them to continue working. So importantly, though, even though it borrows this interactive process from the ADA, the known limitation does not have to be a disability. And unlike the ADA, under the PWFA, a worker is still a qualified employee protected by the law, even if they are temporarily unable to perform one of their essential job functions, so long as that inability is temporary and can be reasonably accommodated, and the essential function could be performed again in the near future. So that's a lot. What does this mean for workers in practice? So I'll give 2 examples. Let's say, for example, a pregnant worker at a big box store is given a lifting restriction and told she can't lift more than 25 pounds for the last 4 months of her pregnancy. This worker can go to her employer and ask for an accommodation so she doesn't have to lift heavy boxes while stocking shelves. The employer and the employee would then work together to settle on an accommodation, be it a temporary change in job duties, reassignment, or any other number of changes that would allow the employee to continue to do her job. So in this case, maybe they agree that the pregnant worker can temporarily take a job at the customer service and returns desk, or maybe reassign heavy duties to a different employee and have the pregnant employee cover some of the paperwork or labeling duties for the employee that has taken over their responsibilities, lifting responsibilities temporarily. So that would be how we envision the PWFA working. Second example, let's say a worker has a travel restriction related to their pregnancy, but their job requires frequent travel out of state. Even though travel may be an essential function of the job, this worker could go to their employer and ask for accommodation that maybe includes remote participation in out-of-state meetings or some other temporary change. So unless the employer can prove that a reasonable accommodation would cause undue hardship, and that means that it would cause significant difficulty or expense to the employer, they are obligated to work with the pregnant employee to find an accommodation that works for them both. Importantly, an employee, just like under the ADA, is not entitled to the exact accommodation that they want. but what they want has to be considered. And an employer can't force an employee to accept an accommodation that was not arrived at through the interactive process. An employer also can't force an employee to take leave if another accommodation can be provided that would be effective in addressing the limitation and allow the employee to continue working on the job. Next slide, please. Thanks. So I said a lot, so I want to recap just a little bit because I know that a lot of people wanted a general overview of the law. So the Pregnant Workers Fairness Act requires covered employers to provide reasonable accommodations to workers with known limitations related to pregnancy, childbirth, or other related medical conditions, unless the accommodation will cause the employer undue hardship. Employees are still protected by PWFA, even if they are unable to perform an essential function of their job, so long as that inability is temporary and can be reasonably accommodated, and they'll be able to perform that essential function in the near future. And employers cannot require an employee to accept an accommodation that was not arrived at through the interactive process. Next slide. So there are a couple other things that I want to make sure to talk about with respect to the PWFA. It applies only to workplace accommodations. So it works sort of hand in hand with the PDA. We still need the PDA because the Pregnant Workers Fairness Act doesn't address, all types of discrimination and harassment claims. So it works together with the PDA to provide robust protections for pregnant workers. The law also does not limit federal or state laws that are more protective of pregnant workers. So there are about 30 states that have their own state pregnancy accommodation laws. If those laws provide greater protection, the PWFA does not preempt those laws. It does include a provision from Title VII that shields religious employers from religious discrimination claims. And I want to be really clear about this. The law does not exempt religious employers. So religious employers are still covered under the PWFA, but there is a reference to Section 702A of Title VII that is incorporated into the bill, into the law. And then lastly, the remedies and procedures under the PWFA are the same as those under Title VII or other applicable federal employment anti-discrimination laws. So this was another question that came up in the poll. There is a requirement to exhaust administrative remedies, and the damage caps that are in Title VII would apply to the PWFA. So the law goes into effect on June 27th, 2023, and the EEOC is tasked with issuing regulations to implement the law no later than December 28th. And we'll talk about that a little bit later. Can we go to the next slide, please? Thanks. So I wanted to go back to the phrase that you've heard me say many, many times now, pregnancy, childbirth, or related medical conditions that's in the PWFA, and that language was drawn directly from the PDA. Important for our purposes today, pregnancy, childbirth, or related medical conditions in the PDA has long been understood to include abortion. The original conference committee report from when the PDA was first passed expressly stated that the law by its basic language includes protections for workers who terminate their pregnancies. An employer simply cannot discriminate against an employee for their decision to have an abortion. This understanding of the statutory language has been the position of the EEOC, is reflected in its guidance, and is supported by circuit court decisions over the decades, and was known to the Congress members who passed this law. The PWFA does not separately define the phrase pregnancy, childbirth, or related medical conditions, so it stands to reason that courts and the EEOC, which will be the agency that is enforcing the PWFA, will rely on the interpretation of the PDA language. This would mean that pregnant workers would have the right to reasonable accommodations for no limitations related to accessing abortion care. So how might this work in practice? And this is a big might because the law isn't in effect yet. And so we'll have to see how the EEOC interprets the law. But for example, an employer might be required to modify an employee's schedule to allow them time to attend a doctor's appointment, including an appointment related to abortion. Or, and this goes back to the first example, one of the first examples I gave, a pregnant employee could request a temporary delay in relocation or transfer to a state where they were unable to access appropriate reproductive health care, including access to an abortion provider. So these are some ways in which we think the PWFA might work to help pregnant workers who are seeking access to abortion. But like I said, regulations implementing the PWFA have not yet been issued. Next slide, please. Thanks. So while the PWFA is relatively simple in its language and operation, there are a few areas that we've touched on where implementing regulations would be very important in understanding how the law will work on the ground. So for example, the law does not list every possible accommodation that could be considered reasonable or that an employee could ask for. There's simply too many, and they're dependent on a person's specific limitation. Folks asked if there was sort of list of possible accommodations. There is a list on the Job Accommodations Network website that you can look at to help brainstorm particular accommodations that might be right for you. But that's just sort of a guide. There's no list, a definitive list, I should say. The law also does not list every possible related medical condition, which again, already includes abortion, but could include other conditions like morning sickness, gestational diabetes, postpartum depression, lactation, on and on. And again, there's some examples on the Job Accommodations Network website. And importantly, again, for what we're talking about today, the law does not specify whether and what kind of documentation, like a doctor's note or other paperwork supporting the need for an accommodation, is required. So I call out these examples for obvious reasons, because there is the potential impact for workers seeking protections while seeking abortion access. And because abortion access and support for workers seeking abortion care could be one of the areas where the EEOC interpretation of the PWFA matters the most, I'm going to do a little bit of a refresher recap on rulemaking and talk about how you might be able to get involved. Next slide. Oh, that's not the next slide. Okay, I'm just going to keep going because I think I have a slide missing. So federal agencies get their power to issue regulations through laws passed by Congress. And often lawmakers leave some of the details of how a law would work in practice to be filled in by subject matter experts in federal agencies. So on the slide here, you'll see that in the case of the PWFA, the bill requires the EEOC to issue regulations implementing the law no more than a year after the enactment date, which translates to the end of 2023. The EEOC is required to include examples of reasonable accommodations addressing known limitations related to pregnancy, childbirth, or related medical conditions, but they will almost certainly talk about other aspects of the law. So what does this look like? In the coming months, the EEOC will issue what's called a Notice of Proposed Rulemaking, or an NPRM, giving the public notice that they plan to publish a rule implementing the PWFA. The NPRM will contain the proposed rule, as well as an explanation of the Commission's thinking on key issues and the reasoning and sources that led them to write the proposed rule in a certain way. After the EEOC issues the NPRM, the public will have a set time in which to submit comments to the proposed rule. So under this process, the agency must review the submitted comments and then will publish a final rule that may or may not look different from the proposed rule, but either way, the agency has to explain how they responded to the comments from the public So they have to explain the suggestions they incorporated or the criticisms that they did not incorporate into the final rule. And this is the opportunity for you all to engage. Sharing your insights and your clients' stories with the EEOC as part of the rulemaking process can help shape the contours of what the PWFA will look like when it's put into effect and can help strengthen the protections of the law. So those of you who work with clients in states that have existing state pregnancy accommodations laws, you could speak to how your state law or regulation works or doesn't work to protect your clients. And that's extremely helpful to the EEOC. For example, if you've seen how medical certification requirements harm workers and limit the protective scope of the law, it's important for the EEOC to know how that requirement could impact workers who, for example, don't have regular or easy access to a healthcare provider. Similarly, if you are living in a state that's hostile to abortion, you might want to talk about why having documentation requirements would put your clients at risk in terms of their privacy and their safety. If they're required to disclose that they're going to have an abortion or that they've had an abortion and need an accommodation. But even workers living in states that protect abortion access, but have an anti-abortion employer. So you live in a state that has laws that protect abortion, but your client or worker works for an anti-abortion employer, they could be dissuaded from seeking protections under the PWFA if they would have to disclose their abortion to their employer. So these comments are extremely important. And I encourage you to submit a comment when the proposal comes out. The EEOC takes these comments really seriously, and they're really important to ensuring that we have regulations that are strong and regulations that can withstand judicial scrutiny. So if you need more information, if you need help in terms of a model, or if you've never written a comment before and want to talk it out, you'll have my contact information at the end of this presentation, and we're happy to talk and to help you out. So I've said a lot and I will wait for questions, but right now I will turn it over to Noelle.
Thanks so much, Galen. That was extremely helpful. And just to kind of underscore your last call for action, requiring any requirement that an employee disclose information to an employer or to anyone else also could certainly raise questions about that individual's potential exposure to liability in their own state. So underscoring your point that it could dissuade individuals. Another thing I wanted to add here is that there's Dobbs, as I mentioned last summer, held that there's no longer a constitutional right to abortion, but Dobbs did not hold that abortion is not medical care or that it is not pregnancy related. There's nothing in Dobbs that should undermine except for the fact that we know this court's ideology. Aside from that, there's nothing in Dobbs that should undermine their folks' protections under the PDA and the PWFA. So yeah, I wanted to share a little bit about resources that are available to you all if you are coming across abortion-related issues with your clients or with anybody that you hear about, and just so you know that these resources exist. So the first thing I wanted to tell you about, and go to the next slide, is the Abortion Defense Network. This is a structure that the National Women's Law Center has helped to launch along with 5 other reproductive rights organizations. That would be the Lawyering Project, the Center for Reproductive Rights, the ACLU, Resources for Abortion Delivery, and If, When, How. We've come together after Dobbs to launch a network that seeks to provide legal advice, information, risk analysis, and criminal and civil representation to individuals who are targeted because of their involvement with abortion, because they provided or they supported someone obtaining an abortion. If, When, How, I'll talk about the other resources in just a second, but to tell you a little bit more about the Abortion Defense Network, we are structured, you can actually move to the next slide. The way we're structured is that this group of reproductive rights organization works very closely with a number of law firms with whom we are able to share information about our analysis of the truly ever-changing landscape around abortion across the country, and provide trainings and provide resources for the attorneys at those firms and other firms in the network who end up representing people facing legal action because of abortion. So you can move to the next slide, actually. There's another resource I want to make sure folks are aware of, the Repro Legal Helpline that is operated by If When How, which is also a part of the Abortion Defense Network, but they separately have had a resource known as the Repro Legal Helpline for several years that is intended for individuals who are seeking abortion or who have questions around their legal rights relating to self-managed abortion. They can reach out to speak to a lawyer and potentially get connected to representation or to funding. The Abortion Defense Network, in addition to legal advice, risk analysis, and representation, is also able to connect people, providers, and supporters of abortion to legal funds that can help cover legal expenses that come up. You can move to the next slide now. And one of those funds is the Abortion Access Legal Defense Fund, which the National Women's Law Center is right now building. That is what I am the director of, and we are set to launch to be fully live on July 1st. The Abortion Access Legal Defense Fund will be available for attorneys to apply to, similarly to the way that the Time's Up Legal Defense Fund is structured, in order to obtain funding to cover legal expenses for abortion patients and for abortion supporters or helpers. And we define that category broadly to include people, friends or family who are helping someone obtain abortion pills, or, providing information, perhaps a teacher or a social worker trying to provide information about abortion, as well as supporter organizations like abortion funds, which are crucial players in the national landscape of getting people abortion care, and practical support organizations which help people navigate the practical obstacles like childcare and transportation to obtaining abortion. So those are all the people that we envision being able to help in the event that they get targeted by either civilly, criminally, by an agency because of their involvement in abortion. So you can move to the next slide. There's several kind of takeaways and action items I wanted to pass along to you all. The first being that this resource is here, and that we know that it is very difficult to understand the interaction of all of the different changing abortion laws. Many of them are written very poorly by state lawmakers, and so they may not be even internally consistent, much less clearly consistent with the rest of criminal codes or licensing or other civil law that exists. And if you run across somebody who needs legal advice or representation, you can always send them to the Abortion Defense Network, and they will get back to any intake within 24 hours and get them connected with someone who can help. Additionally, if you yourselves are dealing with an abortion issue, perhaps related to someone who has an employment issue, and you're looking at PDA or PWFA responses, and you want to consult with an attorney about the potential interaction with potential liability under state criminal or civil law, please reach out to me, and I would be very happy to connect you with someone in the Abortion Defense Network to make sure that you have information that you need to represent your client. We also really want to know if folks in this network are coming across issues touching abortion in your work, so that we can ensure that as we are building, that we're still in very early stages post-Dobbs of understanding how things are going to shake out. And we want to make sure that the work that we're doing is informed by what people are really seeing with their clients and on the ground. Additionally, if you have questions about either the Abortion Defense Network or the Abortion Access Legal Defense Fund, please reach out to me. I basically want you to reach out to me if you have any questions regarding these resources, or if you want to talk to someone about something going on in one of your cases. So that is all from me. I will turn it back to, I think, Lizzie, and thank you all.
Thank you both, Galen and Noelle, so much. That was really incredibly informative and helpful. And I know no easy feat, particularly as this legal landscape is changing on a nearly daily basis, as you pointed out, Noelle. So as we intended, we have ample time left for questions from you all. And I see that you've already started adding questions, which is great. So we'll start with those. And I do just want to name, I'm not sure if you were able to see my response in the Q&A function. I do apologize that our chat has been disabled, and unfortunately we realized too late and weren't able to fix that once the webinar had started. But please do use the Q&A function to ask your questions, and we will absolutely be using that to make sure we are addressing anything that you are curious about. So I'm going to start with this question is probably most directed to you, Noelle, and I don't know if this is sort of really within your wheelhouse, if you have any insight into this, but do you have thoughts on why the US differs from the rest of the world in using both the mifepristone and misoprostol combination versus just the miso that other countries use, if you want to answer that?
Yeah, I think the primary reason is cost, that miso is extremely cheap and easy to access. It's actually used for gastrointestinal issues, was the original FDA approval for miso, and it now has a huge range of use in many OBGYN purposes, including for labor and delivery and IUD insertion. It's used so frequently, and so it was kind of discovered as a pill that could be used in abortion in other countries, and is extremely accessible and safe. And so unlike Miffy, which is approved only for abortion, and went through this like extreme politicized approval process in 2000, miso is just, it's widely available. That's the main answer.
Thanks so much. And I would just encourage others, we have a couple questions to get through, but if you have questions, please continue to add them to the chat. So this next one, I'm gonna send this over to Galen. So you mentioned the PDA using the term women, and we have a question about their definition of women. I don't know if you can speak to that at all.
So I don't think that it does define women. I think it talks about employees. I would have to go back and look at the text of the PDA to be 100% sure. The PWFA for sure does not have a definition of women and talks about employees. I would be surprised if the PDA did, because it was an amendment to Title VII. So I don't think that we're talking about covered employees, and in the PWFA, we're talking about employees who are also qualified employees.
Great, thanks so much. And I know you touched, Galen, on this a little bit, but can you also talk about, so there's a question here, the PWFA essentially essentially functionally comparable to the ADA, but limited to pregnant employees? So can you speak to that a little bit?
Yeah, so the PWFA borrows a lot from the ADA in terms of the interactive process, a qualified employee, but in a lot of ways it's not exactly the same, right? So it's not just the ADA sub-in pregnant employee. So like I said, unlike the ADA, a qualified employee doesn't become not qualified or not covered by the PWFA if they're unable to perform their essential job function temporarily. So that is something that is different. Also, well, and obviously, you don't have to show that you have a disability, right? Pregnancy is generally not a disability under the ADA. But if you have a disability, you could still seek remedies under the ADA. So the ADA is still important and they work together, but there's similarities, but I would say that it doesn't have to operate hand in hand. So even with respect to the interactive process, there was some language in the legislative history in particular that made the point that the process might look different. The requirements could be different for pregnant employees versus what is generally seen as required under the ADA. And that's why it's really important to participate in the comment period, because a lot of this is going to be decided by the EEOC and their reading of the PWFA, the ADA, and so the legislative history that was created.
Lizzie,
I'm realizing I'm muted. Thanks. So I just wanted to say, if anyone else will give people a couple more minutes to add any other questions to the chat, please feel free. While we have these experts here, whether it's sort of big picture questions you've been wondering about, anything that's come up in your practice, we definitely want to make sure we're responsive to what you're seeing on a daily basis. And while we're waiting, I don't want to put you on the spot, Noelle or Galen, but is there anything that you wanted to just talk a little bit more about, since we do have a little bit of additional time? Well, I see another question, so hold that thought. Yeah, so another follow-up question on the 2 medications versus 1. Could U.S. providers just sub? I know that this is something that has been in the news a lot. Could U.S. providers just sub in the misoprostol while the status on mifepristone is so unclear? Do you want to talk to that a little bit more, Noelle?
Sure. Yeah, I mean, subbing in miso only, it is, some providers do provide miso only abortions in the US, and it is a different regimen. And so it's a different regimen. People, when they're taking Miffy and miso, would be taking generally one dose of Miffy to begin the abortion, and then a dose of miso some number of hours later, perhaps another dose of miso. Whereas in miso only abortions, it's generally several spaced doses of miso. So it is possible. Providers in the US prefer, I think people do prefer Miffy versus miso. It is more effective, more consistently. As you saw on the slide earlier, it's over 99% effective. I mean, it's incredibly effective, the Miffy miso regimen. And the miso only regimen is very effective, but it is not as effective as Miffy plus miso, and tends to have worse side effects. But the patient experience tends to be better overall with Miffy miso. But that's kind of, I think those are the general reasons. I think that's being discussed, among providers, I imagine, and folks interested in considering that option, I think would be a good example of someone who should reach out to the Abortion Defense Network if they want to talk about what potential legal risks there may be, and how the decisions may or may not that are currently being issued may or may not relate to miso or have implications for miso.
Thanks, Noelle. While we're waiting to see if folks have other questions, I'm gonna go back to putting you both on the spot to see if there was anything that you wanted to elaborate on that you hadn't had a chance to earlier.
So this is just a general +1 to Noelle's presentation about the ADN. I mean, there are a lot of questions and a lot of things that we don't know, and the legal landscape is changing a lot. And so I think it's just wonderful that there's a resource like this that exists. I know I work at the law center, but I do. And I encourage people to use it, but also to let us know what's coming up for you. We have our contact information there. We definitely want to hear how, I certainly want to hear how the PWFA is working in practice. You know, we worked for 10 years to get this law passed, and I want to make sure that it works for people. So I just want to encourage you. Definitely, I know people always say, contact us. We really do want you to reach out to us, and we want to be partners with you. And, you know, thank you so much for the work that you do, and, you know, your expertise on the ground as practicing attorneys out there in the trenches is just really invaluable to the work that we do as well. So I just wanted to make another plug for that.
Thanks, Galen. And Galen's offer, especially with the comments pieces, I know it's very sincere, and we would love for you all to be a part of that if that feels like a good connection to the work that you do. So if people are welcome to add more questions to the Q&A. We'll be here for a couple more minutes, but I will just move to the last slide, Danny, if you don't mind, just with some concluding thoughts. So first, I want to thank you, Galen and Noelle, for your fantastic presentations. I know how much you put into preparing for this webinar. The insight that you provided today was invaluable, and also thank you for the work that you do every day. I want to thank you, those of you who tuned in, are members of the Legal Network, also for the work that you do every day and for your active participation. We would sincerely appreciate it if you would take just a few minutes right now before you log off today to complete a brief survey. So if you happen to have your phone in hand, you can scan the QR code that's in the purple square. That will take you to the survey on your phone. Danny is putting a link to the survey in the chat if you would prefer to access it that way. And then I also just want to put in a plug for following us on social media. So you'll see our Twitter, Facebook, and Instagram information there. Please follow us on social media if you don't already. And last but not least, if you are tuning in today and you are not already part of the Legal Network for Gender Equity, you'll see a link at the bottom that will take you to a page on our website that tells you more about the Legal Network for Gender Equity, the work that we do, the work that you could do if you are part of it. And it'll give you more information about that, and also how to join if you're interested in doing so. So we will stay on for a couple more minutes. If anyone has any other questions, we would love to be here to answer, but otherwise, please do take a few minutes to fill out the survey. Your feedback really is valuable, and it helps us inform future webinars. And otherwise, we hope you have an excellent day.